Hello, my name is Shalina Hood, and I will be briefing the Marriott Corp versus American Academy of Psychotherapists, Inc. appeals case. Because this case is an appeals case, we will refer to Marriott Corp as the appellant and the American Academy of Psychotherapists as the appellee. The facts, though, remain the same that in the fall of 1973, the two parties entered into an agreement for a convention scheduled for the fall of 1975. Marriott iterated multiple times in writing that they could and would accommodate the convention. 2 weeks prior to the start of the convention, though, the Academy was informed that Marriott would be overbooked and would not be able to accommodate the Academy's convention on its intended start date. The issue is whether Marriott can be held liable for breach of contract for its inability to honor its end of the agreement between the two parties, and whether the knowledge of this incapacity can be found as willful misrepresentation of facts. Did the court make a mistake in its ruling? The appellant's issue is in regards to the trial court's ruling asserting that there wasn't a directed verdict as to count one of the complaint, willful misrepresentation of fact. They wanted a new trial on the issue of punitive damages and thought that there was a mistrial and wanted to dispute that or litigate that. The appellant had 5 grievances for which it wished the court to respond. However, for the sake of brevity in this presentation, I will discuss one. The 5 elements of fraud and deceit in Georgia are significant for proving the willful misrepresentation of fact, or count 1, and they are false misrepresentation or false representation made by the defendant, scienter, an intention to include the plaintiff to act or refrain from acting in reliance by the plaintiff, justifiable reliance by the plaintiff, damage to the plaintiff. The court stated willful misrepresentation of a material fact as herein alleged constitutes misfeasance sufficiently extrinsic to a mere breach of the instant contract to give rise to an independent cause of action in tort, meaning that the employees of Marriott didn't just accidentally breached the contract by overbooking. They had advanced knowledge that they would not be able to accommodate the academy, or they could have rescheduled, but they chose to not evict the larger convention that occurred at the same time. And that was part of the ruling as well. The communication between the attorney and the client attorney privilege became part of the discussion. The Court of Appeals of Georgia agreed with the trial court and denied the appellant's motions for a directed verdict as to count 1 of the complaint, willful misrepresentation of fact, new trial on the issue of punitive damages, and mistrial. The plaintiff led the defendant to believe through written communication that it could and would accommodate its convention. Even though Marriott attempted to mitigate some of the damages, it damages goodwill to contest the original ruling, especially because the defendant met all of the plaintiff's requirements to continue with reservations. The court did not make a mistake in its ruling.